Hello and welcome to Ensuring Success 2016, or welcome back if you've already been here for some sessions today. We are live in Dallas at AMS Pictures and pretty excited about the next session where we're going to talk about recent changes in the labor laws that may affect you if you have employees. So first, a little bit of housekeeping. If you are getting CPE for this session, we will display 3 CPE codes throughout the session. They'll appear at the bottom of the screen. I'll call your attention to them so you can make sure you take note of those 3 codes. And then at the end of the session or at the end of the day, to get your CPE certificates, you'll click the CPE tab at the top of your screen. All of the sessions for the whole day will be listed there, and you just click the ones that you attended, enter the CPE codes that you wrote down during the session, and then you can click to submit that and get your CPE certificate right on the spot. There are also optional evaluations for each session. So also, you can reach us throughout the session and throughout the rest of the day. We have 3 ways in which you can reach us. So one is by email. You can reach us at info@ensuringsuccess.com. Next, you can reach us on Twitter. We are at #DecemberCPE, and we are also on Facebook on the CPA Practice Advisor Facebook page. So wherever you're most comfortable hanging out, that's where we want to hear from you. So if you have questions for our speakers, if you want to share experiences of what's happening in your company or decisions you might have made prior to changes in the law, we'd love to hear about that. So I am Gail Perry. I'm Editor-in-Chief of CPA Practice Advisor magazine, and this session is sponsored by Sure Payroll, and we are extraordinarily happy that Sure Payroll is helping to make this event possible and to make this session possible. So I'm going to quickly introduce our panel, and then they can each tell you a little bit about themselves. Next to me is Shana Chapman, and then John Hagan, Donna Gladys, and Dave Olson. So Shana, let's start with you.
I'm Shana Chapman. I have a small firm in Gallipolis, Ohio, and I specialize in small businesses and the people who own them, the tax return and accounting for those individuals.
And I'm John Hagan. I have a law firm in Allen, Texas, which is right outside of Dallas. And I'm an HR lawyer, so I represent companies when their employees decide to sue them for nasty things like the FLSA violations. And we're very proud to have as one of our clients the Texas Society of CPAs.
I'm Donna Gladys, and I'm an HR coach based in Dallas here. And I work with small businesses as well, helping them set up their HR processes, audit them, streamline them. And I try to help keep them out of trouble so they don't have to call John.
And hi there, I'm Dave Olson, and I own a payroll service company based in Kennesaw, Georgia, just outside Atlanta. We work with small to medium-sized businesses, and it's an outgrowth of having spent years both in CPA practice and the technology side of the tax and accounting industry. So we work as both a service provider and advisor to small to medium businesses.
Excellent. All right, so you might have guessed we actually had a different session planned for today, and then something happened just about a week ago. What just happened?
Well, Judge Mazant up in Sherman, Texas, ordered a final nationwide injunction on the new FLSA changes that were promulgated by the DOL as a result of President Obama's executive order. So basically it's been put on hold, and we wait for the new administration to give us our new marching orders.
Okay, and just you probably all know all this already, but FLSA is Fair Labor Standards Act, and the DOL is the Department of Labor. So this ruling was put on hold. Can we have a little bit of a recap of what that ruling was, before what was going to go into effect on December 1st?
Well, I think the thing that caught everybody's attention, the biggest change for most people, was more than doubling the salary level that would be necessary for an employee to be considered exempt from overtime. There were several other components too, like incorporating some incentives as up to 10% of that total pay. But going from a little over 23,000 to over 47,000 was a shocker for small business all across America. And so that's what really caused the uproar. And I think, from what I've read of the judge's ruling, it was a big part of his reasoning in saying DOL seems like maybe they're taking over some things that ought to be coming from Congress when it comes to legislating based on salary levels.
And that's the big argument. It's a constitutional question, whether or not the DOL and the president have the authority under the Constitution to make these types of rules and expand upon existing rules that were originally enacted in 1938.
Okay, well, speaking of the original ruling that was about to go into effect being a shocker, I got an email while we were planning this session from Shana, who was telling me about how this ruling was affecting her business and clients that she serves in her very small town in Ohio, and it really kind of touched me and made me want to make sure Shana was a part of this panel. So,
Well, thank you very much, because I did. I wrote Gail just out of the blue. I didn't know this panel was happening, and I said, have you thought about, because I'm from a small town, and my town has 3,500 people, and when we say small business, we're not talking what big cities think about as small business. We're really talking about small business. And so this really affected our employers. And where we live, people tend to treat their employees more like family. And so that while they can't pay a lot, and some of these employers don't even make that much money, we tend to take care of our employees, And so we had a lot of people say, the jump. Dave was talking about the jump. The jump from to $47,000 was just a crazy amount of money to go to for these individuals, and we had issues with trying to figure out how to pay salary versus to take them to hourly, and B, people feeling like taking them from salary to hourly made them less important.
Yes.
It hurt their pride that they were now hourly employees. And so those were some things that caught us. And then from a small accounting firm standpoint, we had a double whammy. Our employees may or may not make that threshold. But when you combine that with the fact that you just moved our partnership tax returns up a month, and our employees were going to have to work harder in order for us not to hire anyone else, our employees were going to have to work harder to get those returns done a month earlier, and then you were saying, oh, by the way, they're now time and a half while they're working harder. Some of the smaller accounting firms were going, oh my goodness, now how are we going to deal with that?
So what are we, I think a lot of companies had already made decisions about how they were going to restructure their workforce, and what kind of restructuring were all of you seeing that people had put in place, and in some cases companies are sticking with it because now that they've made their decisions, they don't want to change again.
Right. Well, I've been fortunate that most of my clients scattered around the country were still not in areas that were quite as low wage as where Shana's from. So they were, for the most part, able to make that jump because their management, their non-exempt staff or their exempt staff were already at a level that it wasn't doubling their salary. So it wasn't quite as heartbreaking for them to do that. Of course, now that the injunction is out there and they weren't required to, some of them were asking, well, should I go back? Should I leave things alone? And when you think about the emotional turmoil that you were talking about, it's very difficult to take money back. And just as it was difficult for the ones that had to change their exempt staff to non-exempt staff, salaried to hourly, that was already an emotional toll. So at this point, my recommendation would be hold as you are, and let's let this play out a little bit, because we don't know if it's going to be a few months, a few years before, and I don't know if you have any indication from your dealings on how fast the administration might move based on all the legal requirements, but I think it could be quite some time before we really reach definitive answer.
And it might not be just going back to what it was. It might be
Correct.
something completely different.
Well, one thing that I just happened to be watching the news before this, and I found it very interesting that one of the executive advisors to President-elect actually brought this up on the news this morning as one of the things that they were looking at. He didn't focus on it, so I don't want to say it like that. Okay, we're going to do this. When going through the things that they were thinking about and the stroke of the pen regulations that they were talking about, he very specifically mentioned this. So that gave me a little pause that, okay, while we're all talking about this and thinking it's a big deal, the president-elect has so much going on in his mind. Is he really picking on this particular thing? Well, yes, I think maybe he is. When this particular congressman mentioned it today, it gave me thought that, yeah, maybe this is on his radar. Then it's not just us thinking about it, but at the top level, somebody else is really thinking of it.
Yeah. Well, labor is certainly on his mind. He's representing the downtrodden American, apparently, so that I think this would be one of the major regulations that he should focus on.
One interesting aspect of the scale that we were talking about earlier today is thinking about this in the context of different divides, if you will, among parts of America, which has been a big topic during the political season. And I found it interesting being in the South, which was the region that the Department of Labor found to be the lowest wage region, and they used that as their benchmark for determining this 47,476. And I look at that and I sort of laugh and say, what world are they living in? Because when you look at small business versus big business, there's a big gap. And so small businesses that we deal with around the metro Atlanta area, even though that's a pretty good sized metro area, there's a lot of small businesses that don't average near that level for true supervisor people.
Yeah.
It just doesn't happen in the real world all the time.
Well, we're hearing, we're talking about a lot of situations where people were kind of stunned by the changes in the law that were going to go into effect December 1st, and many of the things we're thinking about are sort of negative reactions, but obviously this law was supposedly meant to benefit people. So where are the upsides of the legislation that was going to go into effect and that might come back?
Well, I think there's no doubt, not taking advantage of your worker and making them work a bunch of overtime. There was that thought that obviously if they're sitting there and working, you need to make sure that they're, they may or may not be making minimum wage. I know when I was a staff accountant at a new firm, coming out of college, I was thinking, am I even making minimum wage with all these hours I'm putting in? And I'm sure I was. So forgive me, my old partners. I loved your firm. I really did. My initial accounting firm was wonderful to me. But you're sitting there thinking about all that kind of thing, and I think that was what the positive was supposed to be, not taking advantage of these people, but the raise was such that it was detrimental to certain individuals. And I'm sure there's other positives too, but that's one that comes to mind.
Yeah, and going back to the small business perspective, the reality for most small businesses is they can't just absorb a whole bunch of additional costs. So their reactions are, well, how do we get the same thing done for the same amount of money? So the workers were not necessarily going to benefit. My favorite example, I have a client who, on the morning of May 18th, when the announcement came out that this is going into effect on December 1, called me up. He was just in the process of building a restaurant, said, I just hired my general manager yesterday, and his salary is well below that level. What do I do? Well, of course, time has gone on, and what a lot of businesses in that situation do is, take a restaurant. It's very common that those managers are going to work 50, 60 hours a week. So their only real alternative is to say, all right, here's how much he agreed to work for. How do I divide that back into, regular hours plus overtime to figure out what the hourly rate ought to be? They can't just pay them more. So the worker didn't really end up benefiting because the business simply had to find a way that kept it within the cost structure they could live with.
Okay, let's backpedal just a little bit because we have a question from someone in the audience who who would like a little more information or description of what the change was from the 23,000 to 47, what that meant was going to happen and who would be affected.
Okay.
Go ahead, Dave.
Okay. Well, you start with the basics that the overtime regulations take into account two primary areas of tests. Plenty of exclusions that I'm sure John can talk about, but people refer to it as the duties test and the salary level test. So the duties test has been there, was still going to be there, but what had been in place for, what was it, like at least 12 years since there had been any change to it, I think it was 2004 was the last change, is that there was this level, 23,660 I think was the number, that in order for a manager who met the duties test to be exempt from overtime, their earnings had to be above that level. Well, agreed. That is
get a salary that could work more than 40
Right.
hours a week, but they just get their salary.
Exactly,
Right.
exactly. So the impact of increasing that salary level test to 47,476 puts a whole different spin on things, because now all of a sudden you got people who truly are acting as managers as envisioned by the law and the regulations. All of a sudden, because of a numeric threshold that has to be met, now they're potentially, we're no longer going to be considered exempt employees and would have to be paid overtime or have their hours limited to 40 hours, which that was one of the other common reactions to it is, okay, I can't pay the overtime, so somehow we got to carve this person's hours back. And some, you spoke of positives or upsides, some saw that as a benefit, of somebody can earn this amount of money and only have to work 40 hours. So that, yeah.
And we're able to do that because not in every case can someone have their employees scale back their hours and
Right.
still, for the company, get the work done.
Yeah.
So that's a real issue as well that we've had to work with.
And the Department of Labor had estimated that if this rule went into effect yesterday, 4.7 million Americans would be reclassified from exempt to non-exempt. And that's a lot of folks,
That's a lot of people.
affecting
It's
a lot of
overtime.
small businesses. And here in the Dallas-Fort Worth area, we're very rich in nonprofits, and it was going to slam the nonprofits and
So
all the good
that's-
work that they do.
And the governmental units, which was one of the
Right.
drivers of the case that was brought, was the states getting together and saying, we can't bear the cost.
Right.
Well, there's some exemptions for nonprofits. They have some, and
They
I
have
don't know
some.
what they are exactly. I know our local Chamber of Commerce, we brought in, the Chamber of Commerce brought in human resource attorneys from Columbus to drive 2 hours down to our little town on the river and go through this with all of our small businesses. It was a packed house because it affects everybody, and that's why we like the Chamber of Commerce. They're thinking about us. And they're a nonprofit, right? So that was one of the things, even, everybody's thinking about how does this affect us? And so a little funny story, when this injunction went through, who emailed us and sent out the blast, because she texted me, was our Chamber of Commerce. She sent it out, and I made a little joke and said, well, now you can send this out at 8:30 at night because it's not overtime. you know what I mean? So, but that was one of the things. It was going to change how work got done too, and it really had a major effect on just so much of how you were going to have to get everything done and what time frame. And going back to our little accounting firms, if somebody wanted to work overtime during tax season and having to ask, can I stay another hour? Well, yeah, it's tax season. We work till it's done, and boy, and we're going in the accounting firm business, we're making a shift to not keeping track of time and value billing and doing all these things. And this took us totally the opposite direction from everything we've been working on for the last 7 years.
Right.
At least that the people I've been with, all of a sudden, I'm looking at my employees and going, oh, all of a sudden, I've got to have you keep track of everything
Back
I
to
didn't
those time
necessarily
sheets.
worry about before. And my staff was begging me, please, no, and I was like, yeah, it's all fun and games till one of you and I love my staff, but it's all fun and games till somebody gets mad and decides to sue.
Right.
And you
Or
didn't
report
follow
you.
the rules. So
Okay, we're going to take a quick break right here. We have a message from our sponsor, Sure Payroll, and as soon as we come back, we will provide you with your first CPE code for this session.
If you pay your nanny $1,900 or more a year, or $1,000 or more per quarter, you'll need to pay the nanny tax. Why? If you don't, you could owe $25,000 in IRS penalties. That's a lot of money. That's like 2,500 yoga mats, or 100,000 diapers, or a little over 2 million fruit snacks. But now you can protect your family and your savings with SurePayroll.com. SurePayroll automatically calculates, files, and pays your nanny payroll taxes so you can focus on your family instead of worrying about late fees and fines. We make it easy and affordable to manage your nanny payroll online from any device. Go to SurePayroll.com and get a free quote for your household, nanny, or small business. Plus, sign up now and get our 6-month money-back guarantee, award-winning U.S. customer support, and 2 months free payroll. Call 1-844-SURE-PAYROLL and mention code 2FREE.
All right, we're back. And if you look at the bottom of your screen, I think you will see a code for CPE. That's the first code for this session, so be sure to record that if you're planning to request CPE credit for this session. So in the break, we were we were expanding on Shayna's comment about the message she got from her friend at the Chamber of Commerce, and she joked that, well, at least now you don't have to record overtime for the fact that you sent this message at 8:30 at night. So that was actually a piece of this that I think was kind of startling to employers everywhere, that especially now with everyone being accessible all the time on their phones, that if an employer sent an email message to an employee at night at home, like if you just remembered something and wanted to, make sure you didn't forget it by morning, that suddenly the employee has to like punch a clock for that. Mm-hmm. So how is that going to work?
And there's definitely a digital footprint for it, right? I mean, it happened and it's recorded.
Yeah.
Mm-hmm. Yeah, and so you get the message, and then you may work offline. How are you going to record that time after that message? The example we were talking about, Gail, during the break, is that what if you send a broadcast email to all of your employees, and a couple of your employees are out on Family Medical Leave Act, which means they can do no work at all, and they open up that email. Well, then the employer has just violated the FMLA inadvertently in that type of situation for a non-exempt employee, or really even for an exempt employee on the FMLA. So you got to be careful with things like that.
So was this legislation put into place without kind of thinking through all of the little parts of it? I mean, was all this supposed to be part of it, or were these surprises that came up later?
Well, the executive order came out in 2014. The Department of Labor only gave us a 60-day comment period, which was way too short for something like this. And the other thing is that while President Obama asked that the FLSA be updated, and it drastically needs update. Yes. Nobody is concerned about that. Nobody takes that for issue. They didn't update all of it. Right. And one of the updates is we have what's called the interstate commerce provision for individuals. And if you happen to engage in interstate commerce, then you fall under the FLSA. Well, not everybody engaged in interstate commerce in 1938, but I would challenge you to find someone who is not engaged in that today. And so that's a given. That needs to be removed. The other thing that needs to be actually upped is the minimum of $500,000 per corporation or per entity. If you make $500,000 or more per year, or annual revenue, then your company falls under the FLSA. They didn't do anything to change that. That needs to be upped, and we can talk about this a little bit later about what we should expect in the future, but I would like to see that up to $5 or $10 million. And then you're going to see not 4.7 million employees going from exempt to non-exempt, but then you're going to see small businesses getting equal footing with big businesses, because they're going to have flexibility that big businesses will not have.
Well, and to go back to your interstate commerce, this was one of the things that when the attorneys came in and spoke to us, and we all went, our eyes got big. We're thinking, okay, interstate commerce, how much are you really doing? Well, I'm on the border of West Virginia. My secretary types a letter and mails it over across the river, and she just participated in interstate commerce. So you're right, it's so much more common. People don't think about it. I mean, you think about, going over and selling something retail or, shipping something, but this is just a service where you mailed a letter and all of a sudden there went your $500,000 exemption, as I understood it at the time. That $500,000 threshold was out the window, and so now it's really the interstate commerce, and everybody, like you said, participates in interstate commerce.
So they could just remove that provision from the FLSA because it's moot. It really is.
So we have a question from one of our audience members who says that his CEO wants to make a mandatory company policy that no one, whether they're exempt or non-exempt, that no one in the company is allowed to work more than 40 hours a week, and they will pay no overtime to anyone. Therefore, if you do work more than 40 hours in a week, he plans to make it mandatory that there will be immediate termination. Can he do that?
Yes, he can. Well, it depends on what state he comes from. But under the federal scheme, he can do that. He can fire them for violating that policy, but he's got to pay the overtime.
Yes.
Okay.
For the non-exempt employees.
Okay.
Now, I would expect that if he tries that, he may have high turnover. So that creates another problem that could be more costly, actually, in the long run. If you think about the expense of having to hire a replacement employee just because they worked an hour of overtime, forgetting, the time because they were engrossed in a task, even if it wasn't pre-approved, and not paying for it, that will also incur penalties for the company. So that's not something I would recommend to a client.
Yeah. I think what that brings up is a topic that's pretty common. You deal with it a lot of times in tax strategy, of how people will get so focused on a tax rule and tax savings, and in this case, we're talking about labor cost and what you do, that they may make decisions that are not good management policy. Just like in the tax scenario, they make decisions that are not necessarily good economic decisions, simply because they're so focused on a law or regulation.
Sorry, I was going to say, I think it's great that the CEO wants to be in compliance, obviously, but there are other ways to accomplish something similar without immediate termination, but putting them the proper way would be to put them through a progressive discipline process where that's considered a violation of company policy, but there's a progression of steps that you go through before you get to termination. So, assuming the employee learns their lesson and doesn't take it, advantage and continue to work overtime that's not pre-approved, then the employee is saved. The company doesn't have those added expenses of hiring someone else. And there's more of a trust level between the employee and the employer.
A side effect of this, that you were talking about the employers and taking care of the employees, because you're right. It's how employers treat your employees is almost, it's very important to maintain good staff. And in our area, you'll have people give extra, days off. This week we're only going to work 36 hours, and I'm going to pay you, but like you worked a full work week. Your salary, I'm going to let you off at noon on Fridays, and we're all going to have a 3-day weekend or whatever. But when you start having to keep track of time, you start to think of, okay, now that I got to pay you time and a half, I'm going to, out of pocket, do more here. So what am I going to have to take away from you? And then that's when the employee is going, I really like that 3-day weekend. Yeah, but now I got to pay you time and a half, and I need you to work 40 hours. Or I talked to another company who said, we randomly give a holiday in a month that doesn't have a holiday. We're very good to our employees, and we randomly say, there's no holiday in this month, so we do an extra holiday in a month that there's no holiday. But now that we have to pay people overtime, that's extra time off. We need them to work that to make up for the fact that we have to pay overtime. And so you start to weigh those decisions of being a good employer that people like to work for versus your bottom line.
Okay, let's take another break. We're going to have a second message from our sponsor, Sure Payroll, and we'll follow that up with our second CPE code. So we'll be right back.
$4.5 billion. That's how much small businesses paid in penalties last year due to payroll processing oversights. That's like 80,000 company cars, or 3 million smartphones, or a pretty much infinite number of iced coffees. But now, you can protect your business and your bottom line with SurePayroll.com. SurePayroll can be used on any device. In just a few steps, you can process and pay your employees. And SurePayroll will automatically pay and file your federal, state, and local taxes. We make it easy and affordable to manage your small business payroll online, so you can focus on business instead of worrying about late fees and fines. Go to SurePayroll.com and get a free instant quote for your small business, household, or nanny payroll. Plus, sign up now and get our 6-month money-back guarantee, award-winning U.S. customer support, and 2 months free payroll. Call 1-844-SURE-PAYROLL and mention code 2 FREE.
And we're back, and the second CPE code for this session should appear on the bottom of your screen. So be sure to write this down and keep a record of it if you would like to get CPE credit for this session. I'd also just like to take an opportunity to point out, you may have noticed umbrellas in front of our desk here, courtesy of SurePayroll, because SurePayroll would like to point out that you can rein in your profits if you use SurePayroll. Okay, so there's probably nobody paying attention to this broadcast who can say they don't know that there was a presidential election recently. I think no matter where you stand on it, everybody knows that there was something going on. So now that we have President-elect Trump in place, what do we expect to happen affecting this ruling that we're talking about?
Well, I think one thing to think about is because the federal judiciary has ruled that there are problems with originating this type of legislation in the White House, I don't think Trump's going to go down that route. I think what will happen is Congress will enact a law that is more favorable to business than the law that was supposed to go into effect yesterday. The Senate will go ahead and pass it, and then Trump will approve it or some modification of it. So I don't think it's going to happen right away. I don't think it's going to happen in the next 100 days. But it's definitely going to happen in the next 2 years while the Republicans control the House, the Senate, and the White House.
Okay. We also have someone who would like a clearer definition of what we mean by exempt and non-exempt employees.
Yeah, one of the things that I run into very commonly in talking with employers is confusion, first of all, between the term salary versus the term exempt. So if you start with the definition, the way I say it is that salary simply refers to a level rate of payment that's paid consistently, period to period, without regard to specific time worked. Exempt from overtime, in contrast to non-exempt, is more a matter of law and regulation, and so based on those tests that we were talking about, you determine, is this particular employee in a category that can be exempt from being required to receive overtime for hours worked over 40 hours in a 7-day period. That's, I think, the most condensed version of what is exempt. It's simply, do you meet the tests? And if so, then fine, your salary becomes an exempt salary. But you could still have an employee who does not meet the test that you, quote unquote, are paying a flat salary. But if they're non-exempt, if they work over 40 hours, they will need to receive overtime, even if you call their regular pay a salary.
Mm-hmm. And that 40-hour work week is based on the federal law. Some states have different overtime thresholds. So,
like California. You get overtime for after 8 hours per day.
Oh, right.
A time and a half there. So the rule to remember is you can pay a non-exempt employee a salary, and this is the rule according to the federal scheme, but you cannot pay an exempt employee hourly and expect to keep that exemption.
Right.
Okay. So if some variation of this law goes into effect after the first of the year, is there any way that it could be made retroactive to December 1st?
Yeah, they can do that, but they're not going to. Practically, that makes no sense. The payroll tax nightmare would be a nightmare.
Well, and this,
You think there was a
one of our
result for the
attendees
election.
pointed out the nightmare of if they make it retroactive and nobody's been tracking their hours,
Right.
then what?
Well, then it becomes he said, she said, and that's we have tons of litigation. There's thousands of lawsuits going on right now in the 50 states about he said, she said, because we didn't track the non-exempt hours because we thought they were exempt or they were salaried or whatever the situation was, and so we try to determine what those hours were.
And who do they favor?
And who do they favor? Well, the Department of Labor is called the Department of Labor. It's not called the Department of Management. Okay, so all ties go to the employee. Okay, but the Department of Labor is very good to work with, and I've been working with them for years, and I think they're very fair. So they recognize that there's a conundrum here, and it's hard when you tell an employee that they can make an extra $60,000 in unpaid overtime for them to say, no, I don't want that. I want $20,000, when $20,000 is actually the truth. And they don't remember either.
Yeah. And one of the things that employers have to be aware of is that employees usually are not a problem until they become a problem.
Exactly.
And when they do, the problem may have been there for a little while before the employee recognized it. You may have seen this, John, but with some of the employment law attorneys that I work with in the Atlanta area, they've shown me examples of, and employers need to understand this. There are free timekeeping apps out there that employees can download. And if an employee is disgruntled and they're looking for a way to get back at the employer, it's a piece of cake for them to download a free app, start creating a record, and then they leave, they're dismissed, they're whatever, they come back and they sue. Now the employee has a record, the employer has none. You talk about, shifting who's got the favor.
Right. And what's a jury going to believe?
Sure.
They're going to believe the written record or the electronic
Right.
record.
And didn't the Department of Labor create their own app for employees to use?
That I'm not
I
aware
believe
of.
I heard that the Department of Labor actually created an app for employees to use for their own protection in cases like that. So, I mean, we see more cases of employees crossing the job duties line, where they're actually called a manager, and employers don't recognize that just the title of manager is not sufficient to warrant someone from being exempt from overtime payments. So we find a lot of situations where a manager is actually performing some of the exemption duties, but not enough to really qualify under the exemption. And so when the employee finds out, they become disgruntled about something. They start talking and they learn, they educate themselves, or there's a lawyer in the family somewhere that says, oh, you really should be getting overtime. And so they end up pursuing that with, the Department of Labor or an attorney of their own. And before you know it, the company has to pay back wages for overtime.
Taxes.
And taxes.
Penalties, fines, and
Those are not light.
and that gets out into the general employee population. And if it's a sufficiently management-heavy company, there could be multiple managers that are,
And you can have
do
class
that.
action lawsuits, which is really hot. There is a way to defeat class action lawsuits according to the law right now, and it's even being upheld in the Ninth Circuit in the California Supreme Court, which is very surprising. But it's to use arbitration agreements that have class action waivers, and that's a whole different topic.
Yeah.
And just one other reason for employers to be a little bit wary. I heard a recent example in a seminar that I was at that was being presented by an employment attorney of how a lot of the smaller overtime claims will end up costing the employer much more, a multiple more in legal fees than the actual claim. They gave one example of an overtime claim that ended up being $6,000, but it also cost $25,000 in lawyer fees that the employer had to pay.
Yeah, and nobody wants to be upside down in that situation, especially the lawyer, because then you have an angry client who won't come back. So,
Yeah.
you don't want to be in that situation.
Okay, so we had a number of employers, I'm sure across the country, who wanted to be compliant and assessed their situation coming up to December 1st and made some changes in their workforce. In some ways, especially if they had employees who were borderline approaching the 47,476 threshold, they had a choice of, and they qualified as on the duties test, they had a choice of either raising them over that threshold so their salary would keep them from getting overtime, or implementing overtime, allowances or whatever, So companies that made some changes in payroll and then found that the rule was overruled, can they wipe all that off? Can they just go back to where it was? Or once you've given someone a raise or a change in their status, can you just take it away?
From a legal standpoint, yes. But from a psychological standpoint,
Yeah.
I'll let mine.
Yeah, that's
I think
tough.
you were talking about the psychological standpoint.
Yeah, that's tough. I mean, we already had the conversation about just taking somebody from salary to hourly. That person may be very willing to go back to say I'm salary again and happy. I don't think people realize what a psychological impact that really was. I mean, that was a big deal.
Very traumatic for some people.
Yeah.
Their whole persona is tied to their job.
Right. But now when you're talking money and all of a sudden they're thinking they're going to make more, especially if you were just like $1,000 under and they were saying, hey, we're going to raise it up $1,000, and I'd look at that company and say you might just want to stay where you are, because you've bought goodwill now at this point. You've bought goodwill with your employees. Think through that.
Right.
Yeah, the case I referred to earlier about the guy that was building the restaurant, he was just starting back in May, and then it just opened last week. Well, on Monday, I had the conversation with him because the ruling came out last week. He was all ready to switch the manager and the assistant manager over to hourly. That was going to be his solution. And so I talked to him Monday. I said, well, it's up to you. You don't have to. And in their case, because the operation was just getting going and people were new, and they really weren't going to have a change in pay, he decided, okay, just keep them on salary. But the psychological component, the management aspect of it is really the biggest factor.
Okay, so for those of you who have clients who are in a situation where where this affects them, what kind of messages are you getting from your clients, and what are their concerns and thoughts about all this?
Well, I sent out an email to all of our clients last Wednesday when this came out, and the response was hallelujah. So,
That it was overruled.
Yeah.
that it was overruled,
Yeah.
correct.
Yeah, absolutely. Yeah, I think one interesting side effect of the whole discussion is that it simply brought a lot more attention back to the issue as a whole. And so we had a number of conversations about the duties test side of it, which I think a couple of you have referred to, that, there's lots of people out there that really don't understand that and are not applying it correctly. So it provided an opportunity to focus a little bit on, okay, let's make sure you got a solid base that you're starting from before you even worry about how this dollar thing impacts you. So that, you could call an upside of it, is that employers were woken up a little bit. And that's needed from time to time because people just get lazy.
Yeah.
Well, I think a side effect also where I live, and without getting too political about it, this all came out before the election. And these small business owners were all saying, wait a second, you're hitting my pocket. And it became an election issue where I live too. It became another thing, Hillary versus Trump, Democrat versus Republican. And and although that's not, dollars and employees and all that, it became a bottom line issue in the election, I think. And I don't think anybody would have thought about that. But when you're all huddled in a room going, what are we going to do? That comes up in an election year. And that was a side effect too, what happened in the election, with at least where I live. That was a side effect.
I would think the timing of it, because
Yeah.
it was so close to the election, really had an impact.
Yeah.
We're going to post the third CPE number on the screen, so just check the bottom of the screen and write down that third number if you're planning on requesting CPE for this session. And I've got another question from an attendee who wants to know if it's the 40-hour rule is 40 hours, because he has a salaried employee who's salaried but only works 20 hours a week. So there would be no effect on that employee. Is that correct?
Yeah, that's an interesting one that I've run into quite a bit, actually. One type of client we do a fair amount of work with is churches, but this is true in a lot of nonprofits and a lot of other types of small businesses where they have part-time salaried employees. And they have a little different set of issues. Number one, that does not make them exempt from the rule. But it actually has brought up in some conversations the side effect of, okay, if that part-time, let's say 20-hour employee, for some reason there's a project or a trip or something that's happening, and all of a sudden that person works 50 hours that particular week, even though they're normally only working 20. There's the other component of the FLSA being minimum wage. And I've actually told a couple of people, you need to take a look at this. You may actually be violating minimum wage standards for those part-time salaried employees because of their fluctuations. So, yeah, part-time gets you into all kinds of interesting permutations.
The other danger with that one is if they normally work 20 hours a week, they receive a salary, and then for some reason they only work 5 hours a week, and the employer tries to cut the pay based on an equivalent hourly rate, they're then violating the salary basis test portion of the Fair Labor Standards Act.
There's never a loophole. There's never a loophole.
And in that case, you
It's
lose
never
your
ending.
exemption, and that employee automatically becomes a non-exempt
Non-exempt
employee
employee.
Okay.
that you need to start paying by the hour or salary with overtime.
And it only takes one week, right? And then you've lost
1
it.
week.
Yeah.
Yeah.
Okay, and we've got another question here from someone whose organization had a state Department of Labor audit, and they determined that a particular position in this organization qualified as an exempt position. There are 5 people working in that position right now, and they're exempt, but one makes over the 47,476 threshold, so they're not required to collect overtime because they're over that threshold. The other 4 are paid much lower and are required to receive overtime. So can we keep all 5 people exempt in this job if this law goes into place, or does the position become a non-exempt position because of the ruling? Does that make sense?
Yeah, it does.
Yeah,
You
I
want
think I
to
understand.
tackle that?
Yeah, so if the ruling, or if the new regulation had gone into effect, the ones that were below that level would potentially no longer be exempt. They would have to be paid overtime. But
Okay.
because the regulation has been blocked by the injunction, and we're still back at that old level of 23,660, then at present, that organization doesn't really have a problem with those 5 people, because as long as they're all over 23,660.
Okay, so if the rule goes into effect as it was written, though, then the one person who's over the threshold is now,
Right, but it's all on hold, so
Okay.
they
Got
don't
it.
need to change anything right at present.
okay. All right.
So,
All right, so what's your advice to employers right now?
Stay the course.
Well, I think, like Dave said, this is a good chance for you to examine your classifications of your employees. And if your employees are asking, why are you asking me all of these weird questions? You can say, well, the law was going to go into effect, now it's not. And so we need just to figure out where we stand with this. And if it turns out that you've got somebody misclassified, exempt, and they should be non-exempt, what I tell our clients is, go ahead and make the correction and tell your employees that we have a payroll error, it's in your favor, and here's $1,500, or here's whatever the amount is. And I have bounced this off the Department of Labor. I've got clients who will come to me and say, I know we're out of compliance. We've got misclassified employees. What should we do? So I asked the Department of Labor that question. They said, just fix it. And if you fix it and you pay those employees, and then one of the ex-employees wants to complain to the DOL about you, if the DOL comes in and does an investigation, then they're going to say, you fixed it, we're going to move on, we got bigger fish to fry, and other laws to enforce.
Yeah. Yeah, the employee communications aspect of it is a tricky one because no employer wants to make the situation worse by saying by saying things the wrong way. One phrase that I suggested to an employer recently they use is and this was actually for a different reason, but to tell the employees, due to the evolution of the regulations, we've determined we need to make some changes, and here's how we're going to do it. Because employees, do always get concerned. They no matter what the change is, and even when it's in their favor, they're trying to figure out, how did this happen?
Well, I think handbooks get stale. You did a handbook 20 years ago, and you're like, all right, we got a handbook, sign off on it for the next 20 years,
Yeah.
But handbooks get stale, so it is really a good time maybe to go through all that information in your handbook and check out your employees.
Yeah.